Right. In this video, I'm going to be putting a case forward for juror irregularity and bias. I'm just going to briefly touch on the incident with the phone call. It's not what the video is going to be about, but just to give you some backdrop. So, excuse for using the mirror. It's just a summary of what went down. Lucy Letby's first trial for the murders of multiple newborns almost collapsed when a malicious caller phoned to claim one of the jurors was biased against her, it has emerged. The phone call, which could have bought Letby months more freedom from prosecution had the trial been called off, claimed a male juror had visited a shop and told the owner that the jury had made up their minds about her from the start. It was received by Manchester Crown Court midway through the jury's deliberation last August. So this is my commentary. When he said made up their minds about her from the start, that's not a neutral thing, because they were talking about being biased against her. When Letby's defence barrister Ben Myers KC applied to appeal Letby's conviction in April this year, he cited this juror irregularity as a reason why the conviction was unsafe and should be overturned. The appeal was comprehensively rejected on all four grounds. Letby was convicted, blah 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 blah. Media restrictions have prevented the media from reporting the details of the defence appeal against Letby's conviction, including the jury irregularity, until today. The phone call was investigated by the court on the orders of the trial judge, Mr. Justice Goss, and the juror in question was approached about the allegations. It emerged that the call was made as a result of an unrelated dispute between the juror and the caller. It became clear that the shop owner had a grudge against the juror's partner and the owner's former colleague after they fell out due to the sale of a mobile phone, the court heard. The juror's partner had been assaulted on August the 2nd by the shop owner after she went to receive her phone, the Daily Mail reported. The issue was dealt with by community resolution after the police were called. According to prosecutor Nick Johnson, he said within an hour or two the complainant was on the phone to the court. This was not mere coincidence. The appeal hearing for Letby was told that Mr. Justice Goss approached the issue very seriously, ensuring he asked him, the juror, directly about the case. The juror reportedly does not agree with the complainant's version of events and says he had never spoken about the case nor visited the shop while the trial was ongoing. Mr. Justice Goss concluded, I've had the benefit of observing the trial jurors over 9 months and questioning the juror today. He answered the questions clearly and in a straightforward manner. Neither his demeanour or answers gave an indication of being untruthful, and he was unaware of what he was being asked. There is no reliable material to show the juror had done anything other than faithfully follow my initial directions. He allowed the juror to continue with the rest of the panel, who carried on with their deliberations until the verdicts were made public 16 days later on August the 18th. And as the ducking stool pointed out, if the juror hadn't visited the shop or spoken about the case, how would the complainant know that they were a juror on the Letby trial? So, I mean, I'm inclined to give the benefit of the doubt, but like I say, what's interesting is that the rumours were, because it's gone through so and so said, so and so's partner's friends, husband's son told me this, that. because it's gone through a few people, you can just take it as gossip. But the fact that they said they were biased against her, and they hadn't made their minds up to say that she was innocent and said against her, is telling. So that's just a prequel. So what I'm going to talk about is baby J, which is the count number 13, attempted murder of baby J on 27th of November 2015. So this baby again isn't talked about much because it's not one that it wasn't the baby didn't die, and she didn't get convicted on this one. But this is what I'm going to talk about as a control experiment. Now, I'm going to go to this is the judge's summing up. So the last thing that the jury would have heard, and lots of people who are pro Letby will say, and I don't necessarily agree with it on all accounts, but they will say that the judge was biased against her, and the summing up of the case was biased against her. So I'm gonna continue on that point. So this case is going to be bias against Letby. So it's the judge's summing up. Okay. The trial is resuming after a short break. The judge refers to the case of child J, born at Countess, October the 31st, 2015. So when was it? November 27th. Okay. After a short time, child J produced some brown bile and was transferred to Alderhay Children's Hospitals for surgery. She had a perforated bowel and was fitted with a stoma. She returned to the Countess of Chester on November the 10th and progressed well, moving into Nursery 4 special care. She had issues with gaining weight, but hospital staff were not overly concerned. Nursery nurse Nicola Dennison said babies with stomas don't tend to grow very well. Child J's mother had stayed with Child J, giving cares prior to leaving on the night of November the 26th to 27th. Letby was messaging a colleague prior to this night shift about how nursery nurses should not be caring for babies with stomas. I think this baby had 2 stomas actually. And there were issues with staffing, saying they would have to send some babies out to other hospitals. During the shift, Child J had 2 sets of sudden and unexpected desaturations. I think so. So where he says during the shift, he's actually referring to Nicola Dennison's shift, not Lucy Letby's shift here, which required resuscitations, and in the latter there were symptoms of seizure. If I'm wrong, someone can correct me, but I believe that's the case. Something Child J had not had before or since. Dr. Bowen said there was no cause for the events. Dr. Evans said infection could not be ruled out. The prosecution said Letby did something or things to cause deliberate harm. The defence say, in absence of any identifiable cause, the jury cannot be sure Letby did anything to harm Child J. Mary Griffith recalled an event at, I think Mary was a senior nurse, recalled an event at 5 to 6 a.m. when she heard an alarm go off in Nursery 4. She saw Nurse Dennison had Neopoth on Child J as she had desaturated. Dr. Khalil Verghese recalled attending once at 5:15 a.m. Swipe data, which is probably wrong, showed him entering the unit at 5:03, probably meant exiting. He said he was told what had happened, that child J had two profound desaturations, the first to the 30s, the second to the 50s. In the latter, child J was pale and mottled. He said at least one of those events was significant. Apart from child J's increased efforts to breathe, child J had recovered well. Child J was moved to room 2 where Letby was. Letby said it was widely talked about that nursery nurses were doing stomas when they shouldn't. She said it was a busy time. She said she had no idea these events were happening. Dr. Gibbs was on the unit when child J desaturated again, this time with a failing heart rate. He said he assisted Nurse Griffith and Letby. Dr. Gibbs noted child J had desaturations to unrecordable levels, the first at 6:56 a.m, the second at 7:24 a.m, plus bradycardia. They were associated with stiff arms, clenching of hands, and on the second occasion the eyes deviated to the left. These were symptoms of seizures. The first took 10 minutes to settle and the perfusion was poor. The second took 5 minutes to settle. Both events required ventilation. Dr. Gibbs could not explain the desaturations, and child J had not presented with these symptoms before. He would say they were caused by a drop in oxygen, but the cause of that was not known. Professor Arthurs reviewed the images of child J after the last collapse. The image was unremarkable. It could not assist in an explanation for this event. In police interview, Letby recalled child J, as she said, had a Broviac line and stoma. She thought she only treated child J after the collapse. She said she had administered medication, as Nicola Dennison was a nursery nurse and not qualified to administer such medications. She accepted searching for child J's parents, but could not recall doing so. In evidence, she said she was aware of the second pair of events, that she and Mary Griffith heard the alarm. So she was aware of the second pair of events. So I think the first pair she wasn't present for, I believe, and saw child J fitting when they arrived. No one else was present. Child J recovered. Dr. Stephen Brewery noted no blood glucose anomalies to explain the seizures, and there was nothing to concern in blood results. Abdominal x-rays did not raise concerns. He had no concerns and said it was a remarkable recovery for her. He did not understand why child J had been hypoxic. Letby was designated nurse for child J the following night and there were no concerns raised. Dr. Evans said the collapses were unexpected. So I just want to read that last one a bit again. Letby was the designated nurse for child J the following night and there were no concerns raised. Dr. Evans said the collapses were unexpected. The second pair were more serious and indicative of something wrong with the brain, and indicative of loss of oxygen to the brain, and could not explain any natural process that had caused hypoxia. Dr. Bowen said infection was not responsible, even though Evans couldn't rule it out, for child J's collapses. I did not come to any major conclusion other than the deteriorations were sudden and unexpected. Thus brings us to the end of the case for child J. Now, why am I reading that? Well, the jury didn't come to not guilty on that case. The jury came to no verdict. That means that at least one of the jury members, at least one, said, based on that biased summary from the judge of criminality, at least one member of the jury said beyond reasonable doubt Lucy Letby was guilty of attempted murder for that baby. So not only is there the usual no evidence of anything, on top of that, of no motive, well, firstly, there's no crime because the baby didn't even die. Again, another. I've said it so many times before. I do not believe that there is any in the world, maybe any precedence for any baby surviving a neonaticide. If someone can find a case of a baby surviving a neonaticide, surviving an attack from any case of any baby surviving an attempted murderous attack, someone please find it for me. So the baby survived, and again the following night, no incidents, and then the prosecution haven't even told us anything to do with what they're alleging let be done. When you go into trial a bit more detail, they say it was consistent with some sort of stopping of breathing, but they couldn't specify. So how can a jury possibly say guilty when the only thing here that has been described, one, there's nothing even pointing to Letby here. I mean, you could just as well say Nurse Dennison was up to no good, or anyone else. But they're not. They're not giving like a period of time when they're not even giving like a brief period of time like they've done with other babies of, oh, the baby was with Letby just for 5 minutes or something when it collapsed. There's none of that going on. There's nothing going. This is just normal hospital goings on, and yet some of the jury have said guilty. So in my last video, the point that I was trying to get across, what was it called again, Bride in the Bath. The point I was trying to get across, and I don't think I got it across very well, was how are these cases getting to trial as individual cases when there's no evidence? Like, because in the Bride in the Bath case, which is apparently brought precedence to using a pattern of deaths, they're just using the other babies as a pattern of death. But this one, with Letby, she's being tried individually when there's no evidence. There's all there is here, and this is, again, like I say, the judge's bias, so-called. I don't find it biased myself, but people are saying the judge's bias summing up. There is no case to answer for here. It's just normal goings on in the hospital. Otherwise, they're saying that the desaturation was unexplained. Well, if there was no chance of the baby desaturating or anything, they wouldn't have bothered hooking it up to a monitor to measure the O2 levels. If there was no chance of it, that's what they've hooked the babies up for, to monitor it, just in case it does that, in case there's a desat. If there was never any chance of it, if they never thought there was any chance of it desaturating in the first place, they wouldn't have bothered hooking it up to a monitor, would they? This is just normal goings on in a hospital, and yet this. So what I'm saying with this case 13 is it's like a control experiment. Literally nothing went on here, and yet they've said guilty. Some of the jury have said guilty. You've got them banged to rights.